Hi, my name is Joe Di Bartolomeo. I'm an Oregon personal injury lawyer. I have offices in Astoria, Oregon and Hillsboro, Oregon. I represent people who are injured in auto collisions or may have suffered an injury when on somebody else's property. And in this video, I'm going to talk to you about the second phase of an Oregon lawsuit. And in my first video on this topic, I talked about how the lawsuit gets started, what we do to start the lawsuit, and what gets the lawsuit at issue, which means that we kind of know what we agree upon in our lawsuit and what we don't agree upon in the lawsuit. So the second phase of the personal injury claim after it's been filed in court is what I will call discovery. Discovery is a legal term, and it basically refers to the exchange of information prior to a trial. So it's after the lawsuit's been filed, but before the case goes to trial. And discovery is a big part of what happens before a case goes to trial, in Oregon. Because what is basically going on is each side is learning about the facts of the case from the other side. So let me walk through the different kinds of discovery that occur before a trial in an Oregon injury claim. So the first thing that we do typically is each side of the case. And when I say each side, I'm talking about us. So if I'm representing the injured person, you would be the plaintiff. The other attorney is representing the person who what we believe was careless in causing the injury. That's the defendant. So what the plaintiff and defendant each do is file a request for documents. In Oregon, we call that a request for production. In the request for production that I typically receive, the defense attorney is looking for medical records, medical bills, accident reports, photographs of the injuries, photographs of the damaged vehicle. That would be true in an auto injury claim. In an injury claim, generally, you will always get a request for medical records and other documents. Now, the thing about discovery is it's not the trial. So what they're allowed to ask for is more broad than if we were at a trial. For example, you may get a request for prior medical records. Those records may never come up at a trial because they may not be relevant to your case. But at this stage in a litigation, the discovery rules basically allow each side to go fishing for information that might be relevant or is reasonably calculated to be relevant. So you're going to get a lot of information requests for documents that may never come up again if the case goes to trial. The second kind of discovery that we most often see is the deposition. A deposition is where a party or a witness gives sworn testimony before the trial. So the legal effect is the same as if you're in court. You are placed under oath, there's a court reporter present, and everything you say is taken down and it could be put into a transcript, and that could come up later at the trial. Now, again, at a deposition, you're talking about what happened in your injury, your injuries themselves, how you were injured, but you're also going to cover or be asked a lot of background questions because that may lead to something relevant. So again, the area of inquiry, the stuff we're talking about in a deposition is much more broad. So that's the deposition. Again, if you want more information, I have other articles that talk more about this in greater detail. And I also have videos that cover the same topic in greater detail. The last type of discovery I'll cover is the independent medical examination. Now, it should really be called the defense or the insurance medical examination, because what is happening is if your health is at issue in an injury claim, and it always is, the defense attorney can hire a doctor of their own choice to examine you and review your records. So basically what happens with an IME is the medical records that we provided go to the defense attorney. The defense attorney sends those along to the doctor. Then an exam is scheduled. You show up at the exam. The doctor performs the exam and writes a report to the defense attorney. Now, some independent medical examiners are truly independent. Many are not. They have their bias just like any other human being. And an insurance defense lawyer will know which doctors have which kind of philosophies about certain kinds of injuries. So I think you know where I'm going with this, but that's the independent medical exam. So those are 3 examples of the kinds of pre-trial discovery that you will encounter after you file a lawsuit. And again, we're talking about the exchange of information before a trial. So if that raises any questions, contact us. We have a contact button above on the website if that's where you're watching this video. I always leave a contact link below if you're watching this on YouTube. If we're not able to help you with your case, if you just have a question, we will get you an answer. And again, if we can't help you, we will find you resources. So don't hesitate to contact us. We love helping people get put in the right direction, even if we can't help them. Thank you so much for watching. I hope this video was helpful. Take care.